What is a lease? A lease is a species of contract for the possession and profits of lands and tenements, either for life or for a certain period of time or during the pleasure of the parties. One of its essential properties is that its duration must be for a shorter period than the duration of the interest of the lessor in the land. For if he dispossesses of his interest, it becomes an assignment and is not a lease. In other words, the granting of a lease always supposes that the grantor reserves to himself a reversion in the leased premises. The estate created by a lease, when for years, is called a term, because its duration is limited and determined, its commencement as well as its termination being ascertained by an express agreement of the parties. And this phrase signifies not only the limitation of time or period granted for the occupation of the land that passes during such period. A term, however, is perfected only by the entry of the lessee, for previous to this, the estate remains in the lessor, the lessee having a mere right to enter, which right is called an interesse termine. Anything corporeal or incorporeal lying in the livery or in the grant may be subject matter of a lease, and therefore not only lands and houses, but commons, ways, fisheries, franchises, castovers, annuities, rent charges, and all other incorporeal hereditaments are included in the common law rule. Rent cannot properly be said to ever to issue out of chattels, but goods, chattels, or livestock upon or about real property may be leased with it, and a rent contracted for to issue from the whole upon which an action for rent in arrears may be maintained as upon such lease. Leases are made either by parole or by deed. The former mode embraces all cases where the parties agree either orally or by a writing, not under seal. The technical words generally made use of the written instrument are demise, grant, and to farmlet. But no particular form of expression is required in any case to create an immediate demise. Any permissive holding is, in fact, sufficient for the purpose, and it may be contained in any written memorandum by which it appears to have been in intention of one of the parties voluntarily to dispossess himself of the premises for any given period, and of the other to assume the possession of the same period. A written agreement is generally sufficient to create a term of years, but in England, by statute, all leases that are required to be in writing must be under seal. All persons seized of lands or tenements may grant leases of them, unless they happen to be under a legal disability, as of unsound mind, immature age, or the like. And although a lease may not be sufficient to authorize a lessee to demand possession for want of a possessory title in his lessor, it will still operate by way of estoppel and inure to his benefit if the lessor afterwards comes into possession of the land before the expiration of the lease. The power to lease will, of course, depend upon the extent of the lessor's estate in the premises, and if he has but a estate for life, his lease can only be coextensive therewith. When for a term of years, its commencement as well as its termination must be ascertained for certainty. In these respects is of essence of a term of years. But although this term may not at first appear to be certain, it may be rendered so by reference to some fact or event. In all leases of uncertain duration, or if no time has been agreed upon for the continuation of the term, or if after the expiration of a term the tenant continues to hold over without any effort on the part of the landlord to remove him, the tenancy is at the will of either party, and remains at will until after payment and receipt of rent on account of a new tenancy, or until the parties concur in some other act which recognize the existence of a tenancy, from which event it becomes a tenancy from year to year, invested with the qualities and incidents of the original tenancy. After this, neither party has a right to terminate it before the expiration of the current year upon which they have entered, nor then without having first given due notice to the other party of the intention to do so. The length of this notice is regulated by statutes of the different states. The formal parts of a lease by deed are, first, the date, which will fix the time for its commencement unless some other period is specified in the instrument itself for that purpose. But if there is no date or an impossible one, the time will be considered as having commenced from the delivery of the deed. Second, the names of the parties, with respect to which the law knows but one Christian name, and therefore the middle letter of the name of either party is immaterial, and a person may always show that is as well known by one name as another. The entire omission of the lessee's name from a lease will render the instrument simply void. Third, recitals of title or other circumstances in the case. Fourth, such consideration must appear, although it need not be what is technically called rent or a periodical render of compensation for the use of the premises, but it may be a sum in gross or the natural affection which one party has for the other. It may also consist in grain, animals, or the personal services of the lessee. Fifth, the operative words of the lease are usually demise, grant, lease, and to farm let. Sixth, the description of the premises need not specify all the particulars of the subject matter of the demise, for the accessories will follow the principal thing named. Thus, the garden is parcel to a dwelling house, and the general description of a farm includes all the houses and lands appertaining to the farm. But whether certain premises are paste of the demise or not is always a matter of evidence. Seventh, the rights and liabilities of the respective parties are regulated by law. In the absence of any particular agreement, are usually inserted in a lease for the purpose of limiting or otherwise defining their rights and duties in relation to repairs, taxes, insurance, renewals, residence on the premises, modes of cultivation, fixtures, and the like. Certain covenants are also implied in law from the use of certain technical terms in leases. In every well-drawn lease, provision is made for a forfeiture of the term in case the tenant refuses to pay rent, commits waste, or is guilty of a breach of covenant to repair, insure, reside upon the premises, or the like. This clause enables the lessor or is assigned to re-enter in any such event upon the demise premises and eject the tenant, leaving both parties in the same conditions as if the lease were a nullity. But in the absence of a proviso for re-entry, the lessor would possess no such power, the mere breach of a covenant enabling him to sue for damages only. The forfeiture will generally be enforced by the courts, except where the landlord's damages are a mere matter of computation and can be readily compensated by money. But in case of a forfeiture for the non-payment of rent, the proviso is allowed to operate simply as a security for rent, and the tenant will be relieved from its efforts at any time by paying the landlord or bringing into court the amount of all arrears of rent with interest and costs. A lease may also be terminated before the prescribed period if the premises are required to be taken for public uses or improvements, or the subject matter of the demise wholly perishes or is turned into house of ill fame. The same result will follow when the tenant purchases the fee, or the fee descends to him as heirs at law, for in either case the lease is merged in the inheritance, since there would be a manifest inconsistency in allowing the same person to hold two distinct estates immediately expectant on each other, while one of them includes the time of both, that uniting the two opposite characters of landlord and tenant.